Mr. Blaikie, you have 7 minutes.
Thank you. So carrying on the same theme, I guess my question would be, outside of the formal consultation process, were there individual companies that contacted the department or met with the department to discuss the integrity regime?
So I'm going to presume you're asking specifically about SNC-Lavalin just because we know what's going on these days.
Yep.
We have an ongoing arrangement with them because of the administrative agreement. So we have regular dealings with SNC-Lavalin. Personally, I have not met with them, but because of the ongoing arrangement, the reporting requirements, there's absolutely an ongoing interaction. As part of that interaction, they have asked questions to officials about the draft policy in terms of getting clarity around how it would work if implemented. So I think that answers your question.
So they have been communicating with the department about the regime.
And if I might add, it wouldn't surprise me if SNC wasn't on that list of 300, but I can't speak to whether it was or not. It's the second biggest engineering firm in the country. It wouldn't surprise me, but I don't know for
We'll
sure.
just confirm right now. They were on the list. They were one we did receive comments from. They are not the only one, but they were on that list.
And for the minister, do you and your government feel that a 10-year suspension from federal contracts is too severe a penalty for companies convicted of criminal charges?
Well, based on, I don't think that question can be answered in isolation. Based on the feedback we received and the international best practice, we determined that if we're going to expand the scope of potential triggers, i.e. offenses that could result in debarment or the business ethics, violations of kind of a business ethics that might be included, if we are going to expand the scope of offenses, that we needed to have a sliding scope of punishment, if you will. So we couldn't justify giving a company a 10-year ban for a labor code violation or an equal ban as to, say, a terrorist conviction. So
yeah, and I think that's something that you heard in the consultation, that the severity of the offense committed should determine the time period of suspension. So, I mean, in your opinion, is the bribery of public officials a pretty serious offense? Where would you put it on the scale of seriousness? If
I'm going to be most responsive to your question, I would say that's not my call to make. We have an independent registrar of suspension and ineligibility who makes these determinations and to whom I have delegated absolute authority.
But you're the
I don't have
minister
any
signing
say in
off. Are you not signing off on the integrity regime? And government doesn't have a role in setting
We will be signing off, yes, on the policy changes, but the application of that policy falls directly to bureaucrats.
Well, then, I mean, it would not be appropriate to have in a policy like the integrity regime a discrimination between more serious charges and less serious charges. That would be an option. So, I mean, I'm just curious to know, do you think that the bribery of public officials is a very serious offense, or do you think it's not a serious offense? Where does it fall on the scale for you and for your government?
Oh, our government doesn't have a position on kind of the hierarchy of offenses. I think it's determined on a case-by-case basis based on all the factors applicable in a case, and it would be inappropriate
there's
for me to
discrimination
take
in the
that call.
criminal code, for instance, between the severity of offenses, and legislation is passed to discriminate between more serious and less serious offenses. So I'm a little puzzled, frankly.
We will set the policy parameters.
Does this have to do with the estimates, really?
Integrity.
Fine, yes, about the integrity regime, but not about the application of the integrity regime. It has nothing to do with the estimates.
Mendez, the reason I'm not giving any extra latitude to this, but I am listening very intently as to the questions and the answers. The minister spoke at length in her opening statement about the integrity regime. Mr. Matthews had talked about the number of individual companies as well as organizations and industries. And Mr. Blaikie is questioning on the integrity regime and exactly the scope of seriousness. I think that's relevant, and I would ask you to continue your line of questioning. If I think it comes to there's a certain line, I will certainly intervene, as I've done on many occasions before, and I think you know me to be as fair as I possibly can in these situations. But I have not heard anything yet which would cause me to intervene again with Mr. Blaikie. You continue, Mr. Blaikie. You've got 3 minutes and 42 seconds left.
Thank you very much, Mr. Chair. Essentially what's happening in these estimates is the government is asking for about $2.5 million to implement an integrity regime. Now, we have a variety of offenses within the criminal code, and nobody thinks that somehow government shouldn't have an opinion about whether certain types of offenses are more severe or not, or that the code shouldn't automatically discriminate between certain types of offenses that are obviously more offensive than other types of offenses. So I don't think it would be inappropriate in the integrity regime to make a discrimination between certain kinds of offenses as being more serious and less serious. The minister herself has said that some offenses are more serious and less serious. So I'm asking her how serious she thinks it is that a company bribes public officials in order to get work. And I'm frankly a little miffed that I can't get an answer. I thought it was an easy one.
Well, I guess what I'm hesitant to say is start creating kind of a list of kind of ranking offenses and wouldn't want that to become in any way kind of a strict pronouncement on what the registrar, who's independent, should take into consideration.
So you don't
what I
think
will
that
say,
in
though,
any
is the severity of the
circumstance-
offense will be one of the factors taken into consideration by the registrar. Bill, can you?
The only thing
No,
I would add,
it's okay. I don't need an explanation from an official. I think I'm asking political questions about the nature of the integrity regime, and I'm still, kind of, well, I'm disappointed that I can't get an answer. I mean, we leave it up to judges, for instance, to make decisions about the severity of particular offenses before court, but that doesn't mean that we can't, in our law, distinguish between certain offenses that are more serious or less serious. So I'm just kind of puzzled that I can't get an answer to that. And the reason why I'm interested is because I do think that for the, you've said that you want to add more charges and expand the scope, recognizing that new charges may be of a lesser severity of the existing charges. But the question is, why can't the 10-year period apply to the existing charges that were recognized as being quite severe? Or do you think that the severity of the existing charges was overrepresented in the original policy?
Okay, sorry, I didn't understand. That was the question. What I would say is we are making a policy choice, if this new policy is adopted, to add flexibility in how, in the registrar's determination of both the severity of the offense and several other kind of factors that they will take into consideration in the decision around debarment and debarment term.
Well, I recognize that there's more flexibility being built in. I guess what I'm disagreeing with is the notion that somehow to have a flexible policy, you can have no discrimination between the severity of offenses at all. Nor do I think that it's obvious that in the case of a serious offense, that the 10-year penalty would be just inappropriate. So anyway, I suppose we'll have to agree to disagree on that one. I am interested to know, I mean, it seems to me that part of the interest in modifying the policy is a concern for jobs and trying to maintain jobs within the Canadian economy and shield, workers from wrongdoings of corporate executives. But I'm kind of interested to know, like, if the changes to the integrity regime that are happening now would provide the government a mechanism for, and you can tell me if I'm wrong about this, but for shielding workers from the consequences of decisions of corporate executives, why then the government would feel that they need to take ulterior paths to do that, like pressuring the former Attorney General, for instance, to abandon criminal charges.
Mr. Blaikie, at this point in time, you're completely out of time. One of your colleagues might want to take up that question further with the minister. Final intervention will come from Mr. Blaikie for 3 minutes.
Thank you, Mr. Chair. Minister, you've talked about the role of the Registrar of Ineligibility and Suspension and indicated that registrar will be making independent decisions about whether or not to suspend companies from bidding on federal contracts. In fact, you liken that to the role of the Director of Public Prosecution, who also makes independent decisions. But we know that in that case, there is the ability of the Attorney General in that case to override decisions made by the Director of Public Prosecution. I'm wondering in the final version of the integrity regime, will there be any kind of ministerial prerogative or government ability to override decisions that are taken by the registrar?
I can confidently say no.
Okay, so those are going to be completely independent decisions, but there isn't going to be anything in the integrity regime that gives any signal in terms of the severity of offenses. So we're going to have somebody making completely independent decisions with no ability for government to review those decisions, but also giving no direction in advance as to what the government would consider to be on the more strict or extreme range of offenses versus smaller offenses.
I will definitely take that feedback under advisement, but what I would say is the severity of the offense is a factor, is something that the registrar will take into consideration. But
there's no guideline for what counts as a severe offense. So for instance, judges make decisions in criminal trials
Right.
about the severity of an offense, but they do get direction through the criminal code. Petty theft and homicide are not treated the same in the code. It's the judge's independent decision
Right.
about what's happened and the severity of that within a category of offenses. But there is direction given in the criminal code as to what's considered a very serious offense and what's considered a relatively minor offense. What you're contemplating is giving no such direction and absolute independence to the registrar. That's what I've heard today. Am I wrong about that? And if so, how?
I understand the analogy you're making, and I would say that's why we're putting in up to 10 years, and the types of things that the registrar will be obligated to take into consideration, including the severity of the offense, will also include prior offenses, will include mitigating circumstances, will include, give me some more examples, guys.
So those factors are documented indeed in the documents that are out there. So things like the role of the supplier or contractor in the offense itself, are they a primary player or a secondary?
Sure, but that's within a category of offense. There won't be any discrimination between classes of offense themselves, and whether some are considered more
severity
severe or
is
less
severity is
severe.
in there, as well as the gains realized. So financial gains, their ability to voluntary disclosure, as well as prior behavior. So that's all a bucket of factors, but severity of offense is absolutely a factor.
So then what counts as a severe offense? And what?
Sorry, Mr. Blaikie, we're completely out of time.